Subscribe now and press the bell icon. Never miss an update.
Five seconds. Several connected appeals and revision petitions have been argued before up, but in my opinion CMA numbers 310, 311 and 312 of 1925 really raised the question of substance which presents itself for decision. If we decide these appeals in favor of the appellants, there our decision in them governs the other cases, and the contentions raised in the latter by the respondents seem beside the point. Shortly stated, the question we have to decide relates to the construction and effect of sections 43, 37 and 27 of the Provincial Insolvency Act of 1920. The facts are undisputed and I shall briefly state them. Three brothers were adjudicated insolvent, first on their own petitions and subsequently on petitions filed by certain creditors. The order of adjudication were passed on the debtors' petitions by the official receiver on the 25th of November 1921, and he fixed 18 months as the period within which the debtors were to apply for their discharge. The same debtors were subsequently adjudicated by the district judge on the 12th December 1921, and the period fixed by him was 12 months. Passing here for a moment, one fails to understand how such sets of parallel orders came to be made, but this curious irregularity has no bearing on the question we have to decide. The total liabilities shown amount to over to 1/2 lakhs. The insolvents had on the 10th of January 1921 executed a mortgage in favor of certain creditors whom I shall in this judgment call the mortgages for about rupees 60,000, and it is said that the mortgage deed comprises the bulk, if not the whole, of the insolvent's property. In the insolvency petition, a proceeding was commenced by the official receiver under section 54 for the annulling of the mortgage. He filed his petition under that section on the 20th of April 1923. Its trial began on the 1st of February 1923 and became a protracted one, the evidence being recorded piecemeal from time to time. In fact, from the 1st of February 1923 to the 1st of May 1924, that is for 15 months, witnesses were examined off and on, but the trial was not, even on the last mentioned date, concluded. I may mention that the evidence of 10 witnesses for the petitioner and 3 for the respondent had by then been taken. On the 30th of April 1924, a creditor by name Krishnaiah applied under section 43 that the orders of adjudication might be annulled on the ground that the debtors had not applied for their discharge within the same time fixed. Several connected appeals and revision petitions have been argued before up, but in my opinion, CMA numbers 310, 311 and 312 of 1925 really raise the question of substance which presents itself for decision. If we decide these appeals in favor of the appellants, there our decision in them governs for the other cases and the contentions raised in the letter by the respondents seem beside the point.
Subscribe now and press the bell icon. Never miss an update.